Hi, Rick Martin here with Martin IP Law Group, back with another installment of our series. We answer your questions about intellectual property and related matters. Today we're going to talk about who owns my IP. Now that might seem like a silly question when we're referring to that as my IP. Who owns a patent initially? The inventor is the initial owner of a patent. So the person that has creative input into the claims of a patent application is an inventor and is an owner initially, at least initially. There could be multiple inventors, joint inventors as they're referred to, and each of those people then own essentially an undivided interest in that patent, and each of them can license it, assign it, do what they please with it. And with regard to a trademark, the owner is essentially the person who is using the mark in commerce for whatever product or service. Copyrights, again, the author, the creator of the work, is essentially the initial owner of the work. Trade secrets, again, the person that maintains the information and keeps it secret is the owner of that, and that could be a business entity, that could be an individual. Those are who owns the intellectual property initially. However, oftentimes an employee of someone who creates a product that may be subject to a patent, or creates a work that may be subject to copyright protection, may have an obligation to assign the rights to that creation or invention to their employer. And that's all contractual, and it could vary depending on what's in that agreement. That's just a little bit of ownership of intellectual property, and how what is mine may not always be mine. We hope that's been helpful and informative. If you have questions as to ownership of intellectual property, whether you own something, whether the employer owns intellectual property, please reach out to us. We'd be happy to sit down and talk with you and advise you on that situation. Thanks again, and have a great weekend.